Committee, and the second new petition today is PE 1491 by Tom Minogue on secret society membership declaration by decision makers. Members have a note by the clerk, the Spice briefing, the petition and a letter from the Grand Lodge of the Free and Accepted Masons of Scotland. For members' information, the previous petitions referred to in the note by the clerk and the Spice briefings were Sydney Gallagher, which was PE 693, William Burns, who was PE 652, and Tom Minogue, it's PE 306. Could I welcome the petitioner, Tom Minogue? Very welcome for coming along, Mr Minogue. And also, we've got Peter Stewart Blacker, who's the convener of Accountability Scotland. Thank you for coming along as well. Clearly, if you want to intervene at any time, please indicate through himself, and we'll be happy to hear your views. I can ask Mr Minogue if you would give us a short presentation of around maximum 5 minutes, Mr Minogue. That would be very appreciated if you could. Thank you all.
Thank you. I begin by asking the committee to take the Spice briefing paper with a pinch of salt, because it's misleading and doesn't tell half the story. And this may not be the fault of those who compiled it, because the Parliament's archives aren't very helpful to researchers. For a start, Speculative Society of Edinburgh was reported here in 2002 and not brought to the public's attention by Robbie the Pict in 2003. The all-male Specs domination of the judiciary was raised by me in this Parliament by way of a written submission in 2002, though you wouldn't know that from the Parliament's summary of Petition 306. However, the official transcript of the Justice Committee's meetings of 30th of October 2002 record this, and you can see it on my Tom Minogue blog. And it's a sad fact that I can follow public petitions in the year 1817, but not in 2003. And this is in the internet age is ridiculous. At the click of a mouse, I can access every issue of The Scotsman and the Glasgow Herald newspaper back to March 1817, and read, for example, about a petition by the Borough of Rutherglen to the Westminster Parliament. The petition proposed electoral reforms and opposed the government's suspension of habeas corpus, but I can't readily find out what happened to my own petition on the 4th of March 2003. And on the 4th of March 2003, Jim Wallace killed off my petition when he gave evidence to the Justice 2 Committee. He told them that Tom Minogue was almost unique, being the only one with a concern about undeclared Freemasonry in the judiciary. Now, that was an astonishing claim, given that it was made at a time when the UK government, as a condition of employment, insisted on knowing the Masonic membership status of new judges in England and Wales, and when Norway had similar rules. In effect, the Justice Minister was saying that public concern regarding judges' Masonic membership hit the buffers at Berwick-on-Tweed and East Coast ports. And the Spice briefing paper isn't even-handed, featuring two cases which United Grand Lodge of England threatened to cite for judicial review of the judges' Masonic registration regulation in England and Wales. But the two Italian cases were never tested in a UK court and are not relevant to my petition. Yet Spice featured them while ignoring and omitting to show a Scottish case that is absolutely relevant to my petition. A case where a Social Security Commissioner upheld the appeal of a Dundee claimant who demanded the right to know if he was being assessed by Masonic decision makers. The Commissioner held that under Article 6 of the European Convention of Human Rights, he had the right to ask. So, two spurious Italian cases featured by Spice, one highly relevant Scottish case suppressed, and I say suppressed because Spice allude to it, albeit obliquely, as additional evidence the Parliament declined to publish. And you might ask why they declined, why was the publishing censored? And the Dundee case is a publicly reported one, and it was discussed with the Justice Minister on 4th of March 2003 in connection with my petition. But you would need a super sleuth, a modern-day Sherlock Holmes, to find it in the Parliament's archives. So to conclude, I would ask the committee to look at my petition afresh, judge it on its merits. In my opinion, this would be done by way of forensic research and examination involving academics, and shouldn't rely solely on those with vested interests, judges and politicians, who, for whatever reason, might want to gloss over this issue. Jack Straw was such a politician. He promised a register of Freemason judges in an election manifesto, was instrumental in introducing it, and then as Home Secretary in 2009, not 2007 as Spice report, but in 2009 he did a U-turn and scrapped it, when, with an election looming and his party trailing in the polls, he sought to gain ground by bribing the Masonic voter. Rather, I would ask the committee to follow the example of a Scottish politician, John McCallion, the first Petitions Committee convener, who boasted that his committee never met in private. That's as it should be, true to the promise that this Scottish Parliament would be open and accountable. Too often I've watched video coverage of committee meetings where the members sit down and rubber stamp briefing papers prepared by bureaucrats, or arrive at conclusions that are the result of private meetings. Some committees remind me of TV cookery programmes, where celebrity chefs produce a perfectly cooked dish with the comment, "Here's one I prepared earlier." Fait accompli is appearing where the public see no due process. That's simply wrong. Future generations should be able to examine every step of this petition process, just as I can read the Scotsman archives and follow those petitions in 1817 which supported the Blanketeers and the Hampden Clubs. Thank you.
Thank you very much, Mr Minogue. And just for the record, to stress that obviously we invited you along today because we wanted to hear about the merits of the petition. And the reason that you're here is so that we can examine your petition and look at the next steps. And I think I can speak on behalf of my committee over the last 2 years to say that we've always been very keen to go the extra mile with every single petitioner. And you'll know that we've had a similar petition involving registration of interest for judges, and you may have seen some press coverage of that, which has resulted in myself and the Deputy Convener meeting the Lord President in a week or so. So the point I'm making is we're not discussing in private. Everything we do is open, and that's the reason that you're here along with your colleagues. So I'm delighted you are here, but just to make sure that's on the record.
If I could just clarify that, Convener, that my remarks were really predicated on past experiences with other committees, and I have watched your committee, in particular Jackson Carlow and co, with Lord Gill's refusal to attend, and I'm very impressed with that. And yes, you're certainly thorough in that respect. I'm basing it on my own experiences with other committees. But could I ask you, through the chair, why we have an additional submission to my petition, one from the Grand Lodge of Freemasons, but when I accepted your invitation, I put additional information forward from the Domstol, the Norwegian Courts Administration Service, and an article from the Guardian's political editor, and they don't appear in the...
Well, could I perhaps suggest what may be useful if I can ask some questions about your current petition and my colleagues can come in? Whilst I totally understand that there's some issues in the past that you wish to air, and you've done that very ably, our job is to look at the current position. We're not really responsible for what happened in the past. We were very keen that we explored your petition. Now, you've touched on one of my questions very aptly, which was that you've mentioned the English and Wales situation, where there was actually a registrar, as you said, from 1998 to 2009 in England and Wales. And as I understand it, that involved judges, police, prison staff, but also probation officers, which was quite interesting. And they were obviously asked to declare whether they were Freemasons. Have you been able to analyse what effectively the results of that period, because that's a fairly lengthy time, wasn't it? That was 1998 to 2009. Have you looked at any academic evidence that's analysed how effectively that operated? Because one of the issues, sorry, partly to answer my own question, was that what I picked up was that for, I think from the effectively the equivalent of the Crown Office, was that they were sending a lot of nil returns back. There was a bit of an issue about that. But that's just one issue I want to raise. Perhaps you could give me your views on it, Mr Minogue.
Well, there was, as you say, a problem with lack of cooperation, particularly with Grand Lodge and with the judges themselves. But I think they got, in their overall conclusions, they decided that, you know, between 5 and 10%, this is on report 2 of the Home Affairs Committee, between 5 and 10% of the professional judiciary in England had declared Masonic membership. Now, if you can extrapolate that with the Scottish figures, which is a highest per capita Masonic membership in the world, more than 4 times what England has, you could be looking at between 22 and 44% of judges here being in organisations such as the Freemasons. But the requirement for England and Wales was ditched, and that's why I put the Guardian article to you, purely because there was an election looming, and Jack Straw, on his own, decided, after having been instrumental in introducing it, decided to scrap it as a vote catcher. And it wasn't anything to do with the 2 Italian cases that are quoted here. It was just, he actually produced a straw man of an argument and gave his reason for scrapping it as they hadn't found any evidence of criminality among judges. But the measures weren't brought in to find criminality among judges. The measures were brought in to reassure the public, to increase the public's confidence in the judiciary, not for any other reason. So it was scrapped on a whim with an election looming by a man who, just the other week there, apologised to the Hillsboroughs family. He got it wrong for many years in that case. I suspect he got it wrong here.
My question was specifically, has there been any academic assessment of how effective that register was when it was operational for England and Wales?
Academic, I couldn't say. They seemed to like it. The Home Affairs Committee seemed to like it, and only Jack Straw, and in his power as Home Secretary, as I say, overturned it. So it wasn't, in my opinion,
I think it was quite
to my knowledge, for any academic reason.
I think it was interesting to look at the analogies because, as you'll recall, it was actually recommended by a Westminster Select Committee to government and then accepted. So I was interested to see if there was any assessment on it. The other issue I just wanted to ask you specifically was, do you have any evidence of wrongdoing by Masons in public life through a non-declaration on any conflict of interest? Because that's probably of interest to the committee.
No. Of course, it's impossible for me to find out wrongdoing by people that don't admit to being members of it. So, no.
And obviously we have the petition, Mr Minogue, and please feel to get involved, Mr Barker, as well, in any questions or contributions.
Could I?
Yeah, do you want to come at this stage? And a final question for Mr Minogue.
Well, Accountability Scotland is about delivering effective administrative justice to Scotland. I don't have any concerns specifically with the Masons. I am much more concerned with the broader aspects of this, that Scotland is a village. People have relationships which can be damaging. I have been subject to one where a chief executive was a co-director with a contractor who had been appointed to a contract where he was unqualified. We need effective investigation. We need assurances that when you sit in front of a civil servant or an MSP, that they don't have a hidden agenda that is not available to us. And that's, we have examples of situations that have been covered up in the health service, in planning law and what have you. And that's why I'm supporting the broader aspect of Tom, who is a member of Accountability Scotland. We came to this rather late. It was only last Saturday that we attended the meeting and discussed this. So we're not perhaps up to speed on the Freemasonry, but Freemasonry is a metaphor for a much broader problem within Scotland.
Just one other point, Mr Minogue, before I ask you a very specific question. In terms of any additional papers that you may have that you wish us to have sight of, there was a point made about the Guardian article. I mean, there's not a problem with that. If there's been any problem with transmission, I apologise for that. If you send it through to Anne Pete, the clerk, that will be taken.
It was sent when I accepted the invitation of this committee.
Well,
the links to the Domstall documents,
sure, the
Norwegian documents for judges, and the article by the Guardian political editor were with
Sure.
that acceptance.
Well, apologies for any reason we haven't received it. The point I want to make clear is that we are very happy to look at any material you have. If you send that through to us, I will ensure that all the members see that and we can discuss it at any future meeting. I suppose the key point and final point for me before I move on is we've obviously seen the petition. What would you say in a couple of sentences? What would you like this committee to do?
I would like this committee to examine the question of a conflict of oaths between the young man who, at 21 years old, is a young law student or whatever, and he follows his family tradition, and he goes and he joins the Masons. And that's fair enough. But it's an onerous business. He has a noose round his neck, he's blindfolded, he bares his breast, he rolls his trouser leg up, and he has a dagger pointed at his breast, and he swears to do certain things and to keep the secrets of that organisation. And he's under pain of having all sorts of horrible punishment. If he doesn't do that, he's going to get his tongue torn out. His body's going to be left to the sea to blow till the wind disintegrates. These are onerous things, and we take it at 20-year-old, a young lawyer would take that seriously. 40 years old, the same lawyer then gets the call to become a judge or a sheriff. Then he's asked to swear an oath to judge without fear or favour. Now, apologists for Freemasons would say, ah, well, he's judging without fear and favour, so the previous sets of oaths, they don't matter. So what kind of man would take the oaths if he didn't mean it? And I see there's a conflict of oaths. There's a promise to prefer your brethren in the Masons that can't be simply dismissed because you become a judge. And I would personally see that as a problem. But my petition's not aimed as what Tom Minogue's worried about. I think people have the right to know if a judge who's sitting in judgment on them and another person, maybe balancing the evidence of two people, one a non-Mason and the other a Mason, is in fact a Mason, or is in fact a member of Opus Dei, or the Orange Order, or the British National Party, because I can see conflicts in some of the demands of these organisations. And this is where I'm coming from. And it's not a question that I just see it, because the two Home Affairs Select Committee reports tell you that all of England and Wales saw it at that time, and there was great public concern. And Parliament didn't spend all that time in it for nothing. And Norway and their government hasn't demanded membership of Freemasonry for nothing. And I would just make it clear that it's organisations such as Freemasons, because to me, you know, Freemasons they're a ubiquitous part of our natural culture. That's a fact. You know, one ex-Master Mason described them as part of the wharf and weft of public life in Scotland. And I've drank in Masonic arms, I've attended weddings in Masonic halls, worked on bridges and buildings that have been inaugurated or consecrated, you know, with Masonic ceremonies. But I can't think of the last bridge I worked on that was dedicated by a senior official of the Ancient Order of Hibernians. And I haven't attended a wedding in the Knights of St Columba's Hall, and I'd be teetotal if I relied on getting a pint in the Opus Dei arms. But if these organisations have similar demands on preferment or bias against people, then yes, of course I would want them to be introduced too. It's just as relevant an argument.
Thank you. I now bring some of my colleagues. John Wilson. Okay. Angus MacDonald.
Thanks, Convener. Good morning, Mr Minogue. Good morning, Mr Stuart Bracker. You've made, and your petition makes a rather bold assumption that Freemasons demand fraternal preference to their brethren over non-brethren, and you go on to mention organisations which have constitutions or aims that are biased against any particular sect, religion or race. What proof do you have that Masons demand fraternal preference to their brethren over non-brethren, and what proof do you have that they are biased against any particular sect, religion or race?
Well, I can get my information. Obviously, I'm not a Freemason, so I haven't taken these oaths myself. So I get my information, as everybody else does, from libraries, from the internet, and from countries that, unlike Scotland, are not secretive about Freemasons, because I find Scotland are maybe very secretive, and unique in other ways as well, Scottish Freemasonry. And no less a person than the Grand Secretary of Grand Lodge agreed with me on this point. He gave me a tour of the Grand Lodge, a nice chap called Martin McGibbon, C. Martin McGibbon. And we talked about the unique aspects of Scottish Freemasonry, which has got an orange flavour, got a sort of sectarian flavour, for historical reasons. And he told me about being in America and seeing bumper plates where it says, if you're a Mason, he said, I live in Glasgow, Tom. Imagine if I was to have one of these on in Glasgow. He says I'd have my car wrecked, because there is this unique sort of secret of nature in Scotland, which doesn't exist elsewhere. And I've heard it from English Masons as well about the sectarian aspect of it. They're shocked when they come to Scotland and there's this orange flavour about it. So I've learnt about it from reading, and I've learnt about it from the University of Life, from bitter experience. I've got negative views of Freemasonry. Some of the best people I've known in my life have been Freemasons, but my general experience in the engineering and construction industry is it's a corrosive influence. It's not a good influence, and that's where I've learned about it from as much as anything. But yes, when I was faced with the circumstances that I was tried, there was no doubt it was Freemasonry that was at the back of it. And logic was stood on its head, and I decided to look into it and challenge it, because I'd experienced it all my life, negative experiences, the very antithesis of meritocracy. I think it's a terrible thing, but that's only my view.
It's your view. You don't have proof, but on your point about openness, it would be helpful, just picking up on the convener's point, to get that document that you forwarded with regard to the operations in Norway. That would be helpful if we can get sent that. Well, we'll get it. Yeah. You'll also be aware, Mr. Minogue, that of cases heard at the European Court of Human Rights, which you've already alluded to in your preamble, which would suggest that the introduction of a law, as you suggest, would breach the right to freedom of association, which is guaranteed in the Human Rights Act of 1998. Now, in addition, the EHCR held that treating membership of the Freemasons differently to non-secret societies was unjustified discrimination. So, if the Scottish Government or Parliament were to take on board your petition, would it not be breaching the European Court of Human Rights?
No, it wouldn't be, because that's not what those cases establish. And Jack Straw didn't rely on those cases. And Jack Straw who has a team of lawyers at his disposal as Home Secretary, never said that these two cases would have blown the legislation out of the water. He didn't say that. He didn't say that that's why he changed the rules and overturned them. He said that the United Grand Lodge of England's sabre-rattling with these two spurious Italian cases caused him to reconsider. And what caused him to change the rules was that he couldn't find any evidence of criminality amongst the judiciary. Do you want me to read that for you?
Convener.
Is it brief, Mr. Minogue?
It's fairly brief. Jack Straw in the Parliament said, the review of his policy, which he carried out because of Grand Lodge's sabre-rattling, has shown no evidence of impropriety or malpractice within the judiciary as a result of a judge being a Freemason, not as a result of the two Italian cases. He found out that there was no impropriety, and in my judgment, therefore, it would be disproportionate to continue the collection or retention of this information because of that, because there was no evidence of impropriety, not because of two Italian cases, one of which, the second one, wasn't even contested, and one of which banned Freemasons from certain jobs. Nobody's suggesting that.
The two Italian cases, surely you would accept that that these two rulings would cause the Scottish Government a problem. Okay, well,
Jack Straw didn't. No. Jack Straw didn't say, we're in trouble with these two cases. Jack Straw said, United Grand Lodge of England have said they might go for judicial review with these, but this has caused me to have a review. And when I do my review, it's the fact that there's no evidence of criminality in the judges. Jack Straw's created a straw man, funnily enough. He's created an argument that wasn't there as regards your Italian cases. The rules he overturned weren't taken to prove criminality among Freemason judges. They were there, and it's quite clear in the two Home Affairs Committee reports, to instil confidence in the public and the judiciary. That's what they were there for, not to catch out crooked judges. So then to say, I'm scrapping them because we never caught out crooked judges, is a straw man argument.
Jackson Carlo.
Thank you. Good morning, Mr Minogue. Can I reassure you I have no vested interest in Freemasonry. I did, as a primary school, take an oath to the Tufty Club. I've never renounced Tufty. I hope that isn't going to compromise me. But the crucial thing when I took my oath to Tufty was it was not an oath in law. And as my understanding is, these Freemasonry, and I have some sympathy with some of the arguments that you mount, if not all, is that it's not an oath in law, whereas any judge is giving an oath in law, and I would have thought that took primacy over any more casually delivered oath. But I want to actually ask you specifically what the practical consequence might be of your petition. Because it says, litigant or plaintiff wishing to exercise their rights to a fair hearing. Is the implication thereby that if a judge was a Freemason, that would automatically invalidate the trial that took place? Or if the plaintiff was a Freemason and so was the judge, would that automatically render the verdict that subsequently was arrived at unsafe? And I'm trying to understand what the practical implication of it would be. And forgive me if I say the practical implication seems to me that it would just create chaos within our legal system. For an oath which is a casually delivered oath, and you actually articulated why I think part of the oath is in some sense a pantomime, in contrast to the very enforceable legal oath which judges and all those others involved in the criminal justice system take. And therefore, I'm uncertain as to whether the consequence of what you seek would not be complete chaos in relation to something that was not a legally enforceable declaration in the first place.
I don't think anyone would say that the judicial system in Norway is in complete chaos because they have a register of Freemason judges. And I don't think that the oath of a Freemason is, as you put it, a casual oath, because it's not done at all. Your word's casual. Casual isn't getting a dagger pointed at your breast and a noose round your neck. No, these things.
As far as I know, the dagger has never been plunged and the noose has never been pulled. So, I mean, to my mind, to my mind, it's all slightly ridiculous, but there is an element of theatre to it. I don't see it as a legally enforceable thing. And to be fair to myself, Norway is not one of those countries I at least regularly point to as being a beacon of all hope and truth and justice in the world today. Others might.
But no, it's not a trivial thing. And I wouldn't trivialise it if you'd done and say it's just a piece of pantomime. And again, in my experience, I've seen Freemasons get away with virtually murder by dint of the fact that they're Freemasons in industry. So I see it as a powerful thing, and I see logic stood on its head when a Mason helps a Mason. And so I see it as quite a powerful thing. I don't think it would cause chaos, and I don't think it would invalidate every trial that was held, but it would help people like me. And people like me aren't, as Jim Wallace said, unique, because it was because of the overwhelming, the groundswell of concern in England about the Stalker affair, the West Midlands Serious Crime Squad, and now we've got policemen investigating the Hillsborough cover-up. They've banned Freemasons from that, so you're going to get another groundswell. And we continually get these, and you've got it in the Met at the minute with the press leaks. You've got public disquiet about Masons subverting the course of justice, and people like me would have the right, which I should have had when I went to trial, to ask if a judge had these obligations. Now, I don't say that I would always even object to a judge. In fact, if a judge wore it on his sleeve and said, I'm a Freemason and I don't care who knows it, I would maybe, because I have had many Freemason friends who have been very good friends and honest men, and I would say, well, OK, I'll put my trust in you. You're a man who wears it on your sleeve. It's this hidden element which, as I say, is peculiarly Scottish, as is the sectarian element peculiarly Scottish, and the massive numbers. So it's all of these things that cause me disquiet. And there are a lot of people like me. Well, I think the 3,116 who supported me in my petition obviously are evidence of that. And yes, I would feel a lot better if judges were open in all of their memberships. And I don't just include the Freemasons in this. Why shouldn't a judge... I could read, when I researched the Speculative Society, I looked at every judge we had, and over 2/3 of our judges were members of an all-male elite from Edinburgh University, the Speculative Society. Now, I could, when I researched that, I could look into these judges, I could tell if they were a member of the New Club, if they were which Burns Club they were a member of, or the Tufty Club, or whatever you like. But I never found out one who declared membership of the Speculative Society. And as soon as you see that, it causes you concern, because Kennedy made a great speech about secret societies and the distrust of secrecy, and it's true. Most people who are in these societies distrust them. They have a mistrust. And it's times in this day and age, in the 21st century, people having nooses tied around their neck, etc. You might say it's a bit of theatre, and making these promises. I don't see it's any place in a modern society. And if somebody's going to do that and pledge allegiance to their brother, then I'm entitled to know. And I'm not alone in this. And I think it was Lord Derry Irvine of Lairg, Lord Irvine, giving evidence to the 1998 Home Affairs Committee, said about this column of mutual aid that we all perceive Masons to have to help a brother in trouble. And he said, when people are in court, and he should know right enough, when people are in court, they usually are in trouble. So it's that side of it. And if I'm faced with somebody getting the benefit of this preferential treatment that a Mason gets, having the edge over me when comparing their evidence, then yes, I'm very concerned. And I would insist that if that was likely to happen in a case, then I would want to know. And of course, it might be that the case I didn't want to know, because say it was a divorce case. I've been married 44 years. Say my wife said, I'm getting rid of you. Now, my wife's from a Masonic tradition, as it happens. But if we went for a divorce case, I wouldn't say to the judge, I want to know if you're a Freemason, because you might favour her. Because, you know, that wouldn't be a concern of mine. So it would only be in certain instances where it would concern me. Each case would be individual, and it wouldn't apply across the board.
John Wilson.
Thank you, Convener. Good morning, Mr Minogue. Can I go back to what your petition says? The petition says, make it compulsory for decision makers such as sheriffs, judges, we've concentrated on judges at the present moment, and juries at their courts, arbiters and all panel members of tribunals that are convened and held in Scotland. Yeah. Now, this seems to extend beyond just judges and sheriffs. This seems to, because anyone can be called to serve on a jury. Yeah. So are you honestly saying that what you would want is everybody that sits in, either as an arbiter or as on a jury, have to declare for the time that they're sitting on that jury that they're a member of an organisation such as Masonic Order?
I think that people who sit on juries in certain cases, and it would be decided, I think, by the legal officials in the case, just like back to Jackson Carlos' question, it wouldn't affect across the board, no. But I didn't have this in my first petition, and I was persuaded by eloquent argument by the late Paul McBride QC speaking on Newsnight Scotland after the Neil Lennon assault case, where he described a completely and utterly inexplicable verdict, the man accused of assaulting Neil Lennon. And he said in Scotland, and I'm quoting him now, in Scotland we have juries who don't have to read, who don't have to write, they don't have to count, and may be full of prejudices, unlike other countries. We may have to visit this area again. So he's alluding to what I've already alluded to, the sort of the historical orange flavour of Freemasonry in Scotland, I think. Of course, I can't speak for him, the man dead, but that's what he said. These were his words. So it just struck me that you could have a jury who, leaving aside the illiteracy or numeracy or whatever, who were members of the British National Party. See, let's move away from the Freemasons. Members of the BNP, 15 members of the BNP, or a majority of a jury of the BNP members judging a black African asylum seeker. Would that be right or fair? And not only that, but as it stands at the minute, nobody can question the memberships of that jury. So when Neil Lennon, an Irish Catholic, was standing trial, I think it might have been fair if there had been a certain amount of jury vetting to see that maybe he wasn't tried in front of 12 Orangemen or 15 Orangemen. I can see it in certain circumstances. Of course, it could be the other way around. It could be a prominent Orangeman standing trial. And would it be right for him to be tried by 15 members of the Ancient Order of Hibernians? I think it's unlikely. All I'm saying is I picked up on what McBride said because in my previous petition I'd looked at my own case, decision maker in front of a sheriff, and the sheriff was the sole arbiter of my guilt or innocence. But I realised after hearing McBride, that's right enough. It's normally a jury. And I don't think it would apply every time, but yeah, why can't we ask a team of jurors? They do it in America. One of my supporters to the petition tells me they do it there all the time.
No, to go back to my original question, I raised the question about people having to make that declaration if they were sitting on a jury. And what you responded by saying is that law officers, only in certain cases, may make that decision. Now, is it only in certain cases we prescribe who can sit on a jury or who can hear a case? Or in terms of the petition that's before us, do you think it should be in all cases? Because you've went through a whole list of organisations and your answers in your opening statement, your answers today, including the Masons, the Ancient Order of Hibernians, Opus Dei, the Orange Order, Knights of St Columba. The only ones that you've not mentioned in terms of is Eastern Star. You haven't mentioned whether or not Church Elders. You did allude to it there in terms of the Paul McBride interview that was on Newsnight in relation to the Neil Lennon case, that we may have a built-in bias in Scottish society that may predetermine the outcome of a judicial case based on the jury sitting there, 15 people, 15 peers, judging a case that may have built-in bias. In terms of the BNP issue, though, if a member was sitting on a jury and was a member of the BNP and it was known to the court officials that that member was a member of the BNP, then I'd expect court officials to make that the court aware of that, or the lawyers acting on that case to make the court aware of the membership of an organisation that has a particular leaning towards objections to colour or religious groupings. But when you start widening this out to include jurors, tribunals and other cases in Scotland, then effectively, who would sit in a jury?
I don't think I'm widening it out at all. I'm talking about juries and the ability to determine from a jury if they are members of organisations that have a bias, that demand a bias of their members, or have a bias against a group. Now, this is where I think that any body that looks at this would have to determine which groups fall into that category. And I don't know of many that would, and I don't think it's such a big thing to ask. Freemasons, Orange Order, BNP, Ancient Order of Hibernians, if that's necessary. I don't think that's a big thing to ask. And I think Paul McBride, and I was quoting Paul McBride because, yeah, I can't speak for him, but I did take on board what he says. That and if it went away from a petition, of course, the bigger thing is it can't be a good system where a man appearing, or a man or a woman appearing on a jury could be illiterate as well. So we aren't looking at a perfect thing here as far as jury goes. And I think that it's not unknown in America, for instance, that jury vetting is quite a big thing based on mainly race there. But so what? If we get a better justice system out of it, is it worth a bit of trouble?
My point is, who determines whether or not someone can sit in a court case, either as a juror or as the judge, a sheriff, or sit in a tribunal when they're hearing a case? Is in terms of the petition, who makes that decision? Because you're transferring, Mr Minogue, let me finish. You're potentially transferring power to someone else who, based on and Paul McBride isn't here to defend why he made the statement that he made on Newsnight in relation to Neil Lennon case. But clearly people who could view that interview will know that Paul McBride made comments that we were unable to question or examine what he meant by those comments. But society in terms of, and the point I'm making is in terms of juries and tribunals, people are asked to serve on these juries. People are drawn in from across society. Who determines whether or not they have a built-in prejudice in terms of hearing a case?
I think that let's say that the prosecutor, the procurator fiscal, or the defender, the counsel for those accused should have the right to ask for a declaration. But I didn't put a perfect document on here that's gone through a subordinate legislation committee and looked at all the small nuances you're putting here. I put a thing forward on a principle, and my principle still holds, and I shouldn't be asked to answer every administrative question about this at this point, surely.
Mr Minogue, the committee members are here to examine the petitions. We're at liberty to try and examine how we take a petition forward, or if we take a petition forward. And we need as much information as we possibly can get from the petitioner to assist us in determining how best to take this petition forward. That's the reason for the questions I've been asked today.
Thank you. We're a little bit short of time, but do any members who perhaps haven't asked a question wish to come in at this stage? At this stage, Mr Minogue, as you probably know from your watching of the previous committee events, that we have a summation section where the committee then decide what the next steps are. So if you could just bear with us for a few seconds. Members will know that there's a couple of options laid out in the clerk's report. One is to seek further information, which would continue the petition, and the second one was to take any other action under which the committee would seem appropriate. It would seem to me that certainly seeking further information on this would make sense. And there's a number of individual groups there, such as Scottish Government, the Lord President, and so on, that we should write to. But are members agreeable we go down that course of action? John Wilson.
Convener, as well as the Scottish Government, the Lord President, Sheriffs Association, the Scottish Justice Association, can I suggest we also write to the Lord Advocate, Procurator Fiscal's Office and Police Scotland to get their views on the petition before us today.
Sorry, we're at the summation now. We need to. We're not allowed to have any further evidence. We need to. Jackson Carlo.
In seeking views, I'd actually quite like them to be sought in two respects. One, the desirability of the issues raised in the petition, and the other, the practicality of the issues raised in the petition, because I think they're quite distinct themes, and it may well be that they affect, our view when we finally consider this petition again.
We have, I think, agreed to write to the Grand Lodge of Scotland just to remind members that David Begg, who's the Grand Secretary, did offer to come in and give evidence before the committee. So I think it's my duty to make sure that members are aware of that offer. Obviously, it's up to members whether they wish to have oral evidence rather than written evidence. I'm frankly fairly neutral on this, but if members feel that it's important to bring Mr Begg in, I'm certainly happy to go along with that. But take members to you, Jackson Carlo.
I'd just like to reserve my position on that offer, I think, at this stage.
Right. John Wilson?
I'd like Jason Carlow, convener, I suggest we reserve a position and invite Mr Begg in at the present moment till we receive further evidence.
Right. Yeah. Other members?
Yes, I think, convener, that's...
Alex McDowell?
I think, convener, that's a sensible move at the moment, and I would just agree that there is merit in contacting all the bodies that have already been suggested this morning for their views.
Thank you. Anne McTaggart?
Particularly of the way forward that's been mentioned.
I'm happy to go with the recommendations. Thank you. Remember, so Mr Minogue, we're going to continue with your petition, and we're going to write to the various organisations that you've heard various members mention, and we're not currently going to ask Mr Begg to give evidence. We're going to reserve a position on that. So we want the fullest possible information. Obviously, we'll keep you up to date with developments. And once we've had all the information back, the committee will obviously discuss that at a future date. And if I can just remind you of my earlier offer, I'm sorry if there's some communication problems, but any paperwork you have you want us to be aware of, please, probably the best bet is for you just to send this when you go home, and we'll ensure it will be circulated round all the members. I can also thank Peter Stewart Blacker for coming along as well. It's very useful to get your views. And can I thank both gentlemen for coming in and giving evidence, and I suspend for 2 minutes to allow our witness to leave. Thank you very much for coming along.
Thank you.
Thank you.